Good afternoon, everyone, or good evening. I am Mateja Đurović, and I'm reader in law and director of the Center for Technology, Ethics, Law and Society at King's College London. And most importantly, I'm one of the editors of the amazing Journal of European Consumer and Market Law that is actually hosting this session today. May I ask someone who is pleased to switch off
microphones.
their mic, please? Yes. Yeah. So it would be great if only the speaker or the speakers have the mic on, please. Thank you very much. So today we have an excellent workshop where actually two authors will present their outstanding paper on dark patterns, or in particular kind of dark patterns like to be found in Europe's consumer protection regime. If you want kind of if you get very inspired by the presentation, and I'm sure you will be, you find the published version of this paper in the issue 6 of our journal for the previous year 2021. So you can all have a look at it. So how does the day will look today? How our like this afternoon/evening session will look like? First of all, Mark and Mireille will be talking about their paper, presenting about the main kind of findings and conclusions from their paper for the duration of 25 minutes. And this is then going to be followed by comments, first by Agustn and then by Mateusz. Okay, so the speakers will be Mireille Caruana from University of Malta and Mark Leiser, who have jointly authored this excellent paper. And the commentator will be Agustn Reyna from, I think many of you know him, or at least you have heard of him, because he's a leading competition and consumer lawyer, and he's been working for many years for BEUC, which is the European Consumer Organization with its seat in Brussels. They've been doing a lot of interesting stuff all these years, and especially now in the context of new technology consumer law, as well as my dear colleague and friend, also an editor from the Law Journal, Mateusz Grochowski, who is currently at Max Planck Institute for Comparative International Private Law in Hamburg. There we'll have some time for discussion and for the question of the audience. I'm very kind of looking forward to the presentation and to the topic, because as we can see that in the previous years, or at least when I kind of was doing my PhD, I remember on consumer law, there was very clear separation between consumer law on the one side and data protection law on the other side. Likewise, there was also very clear kind of separation and lack kind of even communication interaction between consumer law scholars and digital law scholars, kind of specialists in the area. But now we can see that these two areas of law are really kind of merging, and there is kind of this borderline that separates them is blurring. So that's why I kind of find particularly interesting this topic, and to see how maybe the existing consumer law can be also used in the context of dark patterns, which are usually approached from the perspective of data protection law. And this is all part of one kind of wider discussion on what should be the response of the traditional consumer law towards the development of the new technology. Because as I keep saying, these new technologies definitely on the one side should not be kind of disproportionately prohibited, inhibited their development by the consumer requirements. But on the other side, some fundamental values of consumer protection need always to be maintained, need always to be protected, irrespective of the technology that is being deployed. So many thanks. I won't be speaking anymore. Please, Mireille and Mark, I don't know how you have divided your time, but the floor and the 25 minutes are yours. Again, many thanks for submitting your paper to our law journal, and many thanks for kind of being with us here today.
Thank you very much for that wonderful introduction. I'm going to start off the presentation today with a little bit of a background and putting the paper into context and how we came about writing it. I do so because I actually think it's quite an interesting story that's quite enlightening in itself. Mireille had asked me to come out to the University of Malta to give a public talk on fake news. And when we were there, at some point during the visit to the University of Malta, I distinctly recall that there was a very severe thunderstorm that knocked the power out, and we had no internet and no TV. In fact, I remember the TV in Mireille's room kind of exploding as a result of a direct lightning strike. And what it meant at that moment was we didn't have anything to do. And so I was resorted to looking through her library and the books on the shelves, and I picked up a book on consumer protection by Stephen Wetherell to kind of see what was going on there. I was educated in the United Kingdom. I also did my PhD in regulation of information technology. And I'm ashamed to say, actually, in hindsight, that consumer protection played zero part of my education. I mean, we didn't have classes in consumer protection, in information technology. And as you kind of indicated that in your own experience, data protection was at the forefront, and that's what we spent most of our time talking about. Mireille and I share a common feeling or common concerns about a number of problems with the data protection regime. The first is that it's ever expanding, which has the knock-on effect of causing problems for the purposes of enforcement. And second of all, it's regulating the processing of personal data. And as a result, at the time, maybe going back to 2016, 2017, we didn't really have anything else. We didn't have the Artificial Intelligence Act. We didn't have any other regulation of information technology that came close to the scope that the GDPR did. And when we started looking at some of the problems that people were complaining about online, or we were trying to tackle in some of the narratives and discussions that people were having on, I think Mireille and I, and maybe I'm speaking for her here, but we both felt that there was some shortcomings in the data protection regime that was going to have either a perverse or absurd interpretation in order to solve the problem, or that it relied on phrases that didn't necessarily get to bringing the harm under control. So we thought about transparency, for example, and we were both very concerned that people were placing too much emphasis on the idea of transparency as a principle that would regulate all of the things that we were experiencing online. And as a matter of fact, the book and I opened up was, I flipped through this chapter and I landed on a page which in this consumer protection book, where it was a kind of paragraph about a blanket comment about evidence suggesting that transparency is not as great a mechanism for ensuring protection as maybe we assumed it was going to be. And around the same time, I was asked to participate in a privacy camp for students of information technology in the Netherlands, where I'm based. And the theme of this privacy camp was dark patterns. And what I noticed amongst the students there was that when you give them a dark pattern, the default practice was to look to data protection to try and solve the problem. And this is completely understandable. It's maybe an indictment of our educational system that we should probably rethink a little bit. And then we put so much emphasis on data protection as the means for solving the problems that we experience online. One of the second things that happened in that privacy boot camp was the takeaway that nobody knows anything about consumer protection and information technology. Students are not taught it, and that there was mechanisms within the regime that could go a long ways to helping understand some of the design techniques that are being used by apps and platforms that trick us into our agreement to terms and conditions or to the processing of personal data. One of the speakers at this camp was a guy, an academic from the States called Colin Gray, who is what we would refer to as design ethicist. And he really has been instrumental at having developed these kind of narratives and typologies that we are commonly referring to now when we talk about dark patterns. And his presentations during that camp were extremely enlightening. And there was just a never-ending, one of the things that my takeaways was just like a never-ending list of dark patterns and different types of dark patterns with these like really colorful metaphors, like Roach Motel and privacy zuckering and things like that. And I thought, the work of the design ethicist is very helpful. But when I looked into dark patterns further, there was two major problems. The first, it was a never-ending list. That people were using the term dark pattern to describe problems with the user interface that they didn't like. And it didn't necessarily mean it was against the rules or there should be a reason for regulatory interference. And so I said, okay, we've got all these dark patterns that are being listed. And they're there, but are they all problems that the law should be quick to regulate and interfere with, to have a regulatory intervention? And so the first sort of step that I took in that space was kind of analyzing the taxonomy of dark patterns. And so we went through all the academic scholarship, looking at the various categories. And again, you see these kind of metaphors for problems like nagging and roach motel and sneak into basket and toying with emotion, which weren't particularly helpful. And what I also took away from that exercise was that there was several types of typologies that were just basically building off of one another. And so I didn't think that was particularly helpful for solving the problems, because I think we all experience these difficulties when we go online, where we have pop-up windows, or my phone is constantly sending me notifications asking me to consider doing this or consider doing that. And I can't escape them. I mean, I need my notifications for some of them on, and I don't have the ability to turn them off. And so they're just constantly there and taking my attention away from whatever I'm working on at the time. So if you are familiar with this topic, you'll probably be familiar with some examples and some work in the space from data protection field. And there is a wealth of scholarship that's in this space, or an emerging body of scholarship emerging in the space. But I think it's emphasizing data protection at the expense of any meaningful dialogue about consumer protection. And so these are some examples that you will see in the Norway Consumer Council, their Disease by Design report that came out a couple of years ago has been incredibly influential in driving the dialogue in this space. There was a couple of academic papers that came out about the analysis of shopping websites to see whether or not they were deploying dark patterns, the Matter Michael Veal paper, for example. And many of these things were practical, or these examples are just practical examples of what you would see when you look at data protection or dark patterns from the perspective of data protection, reward and punishment. By tapping I accept, you accept the updated terms. Then you see your options, and the only options there are to close or delete the account. But these certainly aren't the only ones. Some examples from consumer protection. I remember actually experiencing this firsthand as a consumer. I tried to purchase a ticket on Ryanair, and I had the option to buy travel insurance, but there was a default. Apparently, you have to go to the country of residence, which is called no travel insurance required, which is listed somewhere between Latvia and Lithuania. It's not even in alphabetical order here. So, but that was a good example of something that was really annoying. And if I was scrolling down to the United Kingdom, possibly I would miss over that option to deny travel insurance. There's a variety of other types of dark patterns that have certainly a lens of consumer protection. I'll give you a couple of examples here. This is what we would characterize as hidden costs. There's also price prevention. There's also our price comparison convention. There's also disguised advertisements. There's also trick questions, and that's one of my personal favorites. Are you sure you want to cancel your order? Okay, or cancel. Like, which one do you actually click to cancel your order? So these are where I think that the consumer protection has a place to interject and regulate dark patterns. So with that in mind, if I could just move forward to the next step in the process, which was to kind of look at some of the shortcomings of data protection and the limitations of data protection. And I don't necessarily mean that data protection is limited and it can't do anything. I think that some aspects of data protection, there isn't a body of work developed yet that makes the rules clear. And I also, there's elements of some of the problems of interpretation where we're presuming that the EDPB would rule in a certain way, or that the data protection regulator in member states would come to the same conclusion as some academic scholarship indicates or suggests that they would. So for example, in data protection, we would think about consent and this incredibly high standard for agreement, but we don't talk an awful lot about the withdrawal of consent and the mechanisms for removing that the ground of processing. Edwards, Lillian Edwards, in an old book on information technology, still refers to consent, or referred to consent, as a magic wand that could be waved by any popular online service to secure itself a revenue stream of personal data while remaining legally compliant. And what we argue in this paper, in a very roundabout way, in some places I think quite directly, is that the consent mechanism actually has driven dark patterns. What you have to do is to prove to the regulator that you got consent. And so the design of the user interface has been instrumental, or the way that the interface is designed is instrumental in proving to the regulator that you were able to achieve consent. It doesn't mean that it was freely given or unambiguous or specifically informed. It simply means that the mechanism has been implemented into the design in order to get consent. Transparency, originally coupled with fairness. It's a tool for regulators, but as we already discussed, it doesn't, I'm not sure that it really works for data subjects. That people, because they are made aware of something, don't necessarily change their behavior in a way that the regulator or the regulation is intended to do. And a general right to know, I think we argue in this paper as well, that a general right to know doesn't necessarily prevent harmful processing. And even if you are fully aware, transparency is always trumped by the network effects, that people might be aware that they're agreeing to the processing of their personal data to the detriment of their soul and integrity, but they still join a network or a platform because their friends are there and their family are there and colleagues are there. Damien Clifford did a wonderfully long and detailed account of fairness in the data protection regime. And there's just, the conclusion is just limited development. It's always been tied to other principles. And so we just don't have any body of law in data protection yet on what fairness means in a meaningful sense. And I also think there's limited applications of the data protection by design and default, which we explore as well. However, consumer protection has, even to the novice, I think it has a series of very obvious applications to many of the dark patterns that we see online. As I mentioned earlier, my phone is constantly beeping with notifications. Would you like to X do this, or don't you want that, or don't you want this? The lack of a no option, unsolicited consent pop-ups. I could probably tell you 3 websites every single day of my life asks me to accept and continue, or maybe later. They don't give me the right to deny. And then every time I go back to the website, I have to go through the same mechanism. Deceptive presentation of information, misleading practices. And by compared to the data protection regime, I think that the consumer protection, one of our conclusions was that the unfairness or fairness is a considerably well-developed doctrine in comparison to fairness in the data protection regime. So our original take when we looked at the paper was that there is a significant role for consumer protection to regulate these types of practices. And I focused my energy on the EuCPD. And if anybody knows my background, I unlike many people in the IT field who kind of merge data protection with computer science, I look at things a little bit differently because I come to it from a cognitive psychology point of view. And so it struck me that there was a kind of cognitive awareness was kind of built into the EuCPD, and that there was recognition that there are certain things, recognition already existing in the law, that certain aspects of cognitive and economic well-being can actually impair your decision-making, which I don't think is embedded in the data protection regime at all. As you all know, if you're familiar with this, it requires an average consumer, reasonably well-informed, circumspect observer, and it's built on the idea of rationality and the right to self-determine whether you're going to enter into a transaction. But what I found really interesting about the Compro regime was that there is an emphasis in the pre-contractual environment by imposing a mixture of conditions. And those are information transparency and also direct bans on practices that takes advantage of those shortcomings that consumers often exhibit. And I know that many practices we try to say that is banned in the data protection regime. It's a prohibitive regime, but it's very difficult to actually ban a practice under the GDPR because you always have the mechanism of consent that people might actually agree to these things in the first place. So I also have to say that when I looked at the consumer protection regime, it also covers advertising and the pre-contractual environment, and leaving an environment was also regulated. And that was the kind of eureka moment for Mireille and I, was, okay, well, if we can regulate the process of processing or the process of entering into a contract before it happens using consumer protection and the Unfair Commercial Practices Directive, then we can do something about dark patterns, because dark patterns are also characterized as making it difficult to leave a platform. So I think Amazon has a very famous case of requiring 13 steps to leave Prime, and compared to 2 that are required to actually enter into an arrangement with Amazon Prime. So I have to say, and I know my time is probably coming to a close here, but what this paper served for us was, and I have to say, it's also been, we were talking about this today, Mireille and I, that 18 months since we originally started writing this paper, but we didn't stop working. We kept going, and we feel that this paper became a bit of a bit of a foundation paper for continuing the work on dark patterns. We certainly didn't stop, and so the paper is written in a way which embraces the kind of New Deal for consumers, analyzes the present frameworks and their application, and serves as a starting point for hopefully what we will see as other people building on top of this paper with their own analysis of how various forms of consumer protection can be instrumental in successfully regulating dark patterns. The next step for us was taking dark patterns and putting it into the language of the EuCPD. And we went through this exercise of splitting the common types of dark patterns that can be regulated by consumer protection into the information asymmetry and free choice repression. And then the final point, which is not in this paper, but this, I hope, gives you an idea of where the work is going, was that we split all the different types of dark patterns that are recognized by the design industry. We then looked for what the actual intent and outcome of the dark patterns were, characterized them in the framework of a my own taxonomy of dark patterns, and then applied the relevant UCPD provision to the dark pattern itself. So hopefully this will give a starting point for a launch pad of using Compro to resolve the issues of dark patterns. And I will then hand over to Mireille to talk quickly about enforcement.
Thank you very much, Mark. And just in the context of what you have said at the beginning, that you studied in the UK and there were no consumer law classes, I have to tell you, that things have changed, and now actually at King's we have every year more and more students attending, modules both undergraduate and postgraduate in the area of consumer law, and I'm emphasizing this now because several of them are now the current consumer law students, and of the from the previous years are now attending this talk. So this has fortunately changed. Thank you very much.
Thank you.
Mireille, please.
Good afternoon. So I would follow up by talking a bit about the enforcement envisaged in the consumer law acquis. And I brought together here some common elements that characterize this enforcement mechanism. The consumer law acquis requires that adequate and effective means exist in order to ensure compliance with the directives in the interests of consumers. Now, the facilities are not fully harmonized, but can vary between member states. Public bodies and/or consumer organizations and/or professional organizations with a legitimate interest may take action under national law before the courts or competent administrative bodies. That is to say that the national procedures are not harmonized, are not uniform across the European Union. Sometimes the person with a legitimate interest will take legal action. Other times they will bring their complaint before a competent administrative body, which may have the authority to decide on the matter or to bring appropriate legal action. And in either case, there may be a prior requirement to refer to some other body, which may, for example, enforce a code of practice. Now, as regards to what kind of enforcement may happen, basically, there is the possibility of prohibiting or stopping, ordering the cessation of dark patterns, which harm or pose a threat of harm to consumers even before any contractual transaction may have been entered into. We also noted the amendments introduced by the Directive on Better Enforcement and Modernization of Union Consumer Protection Rules, which require effective, proportionate, and dissuasive penalties in case of infringements, and increase financial sanctions for non-compliance. This increase in financial sanctions also seems to mirror similar developments in the data protection field. Penalties which speak about 4% of annual turnover, or if this is not known, a minimum penalty of a maximum of 2 million euros for cases where there is a widespread infringement with a union dimension. Next slide, please. So specifically under the Unfair Commercial Practices Directive, apart from what we've already said, Article 11 also provides that action may be taken by those with legitimate interest in combating unfair commercial practices, including competitors. So here you have a specific reference to an interested party, a competitor, who is also indirectly harmed by the use of a dark pattern, for example, and the action which they may take, the competitor aids in the enforcement, which benefits a third party, which benefits the consumer. Once again, the more recent amendments, part of the New Deal, modernization of consumer law, so the Directive on Better Enforcement and Modernization has a new Article 11A, which provides that access to proportionate and effective remedies includes compensation for damage suffered by the consumer. So here, apart from orders to seize or that prohibit the continued use of unfair patterns, there may also be an issue, 5 minutes is fine. There may also be a remedy of compensation in the case of any damage or loss to the consumer. Next slide, please. So one interesting development in the consumer protection field is the is the issue of having representative actions for collective actions. The current law enforces a directive on injunctions for the protection of consumer interests, which covers injunctions aimed at the protection of the collective interests of consumers, included in certain directives which are listed in an annex. And this annex includes the consumer protection legislation, which in fact we analyze in our paper, including the Unfair Commercial Practices Directive, but also the Consumer Rights Directive and others. This closed list was identified as being problematic because injunctions may not then be available where a consumer interest concerned is protected under data protection law, for example. But the list, in fact, this particular directive is set to be repealed and replaced by a new directive, which will be in force, which is already in force, but we are currently in the transposition period, and it will be applicable from June of next year. And under the new directive, this list has been broadened and the GDPR is indeed included. So we'll begin to have these interactions, of course, between between consumer law and data protection law. So a consumer authority or association can file for an injunction prohibiting the continued use of a dark pattern if the dark pattern is identified as an act contrary to the directive as listed in Annex 1 and if it harms the collective interests of consumers. Next slide. Next slide, please. So this new directive, which, as I said, is currently in a transposition period, is a directive which provides for class actions, what the US would call class action, representative actions. It will replace the injunctions directive with the overall aim of strengthening enforcement of EU consumer law. It introduces a class action style litigation for consumer across the EU, and qualified entities as defined in the directive are entitled to seek at least the following measures. Injunctive measures, as we said, this could mean a measure, an order by a court to seize or to prohibit the continued use of a dark pattern without, however, any need to prove any damage or loss to an individual consumer or indeed any intention or any negligence on the part of the trader. But there would also be the possibility of seeking redress measures such as compensation. Next slide, please. So we wrote a note comparing this regime to that found in the GDPR. Indeed, in some way, it is a stronger mechanism than that found in GDPR because the GDPR Article 80 only provides for the right of a data subject to mandate a not-for-profit body, organization, or association to exercise the right to receive compensation referred to in Article 82 on his or her behalf were provided for by member state law. So in this sense, the consumer regime goes a bit further. On this issue, but it is also to be noted that this new directive is actually without prejudice to other enforcement possibilities found in other laws. So indeed, there is currently an ongoing case referred to as Facebook Ireland, where a preliminary reference has been made by the Court of Justice in Germany. And just last December, the opinion of the Attorney General was published. And this concerns whether a consumer association may bring an action, a representative action, under the GDPR, actually under Article 8 sub-Article 2. And the AG is opining that this should be allowed in the case of an infringement of the GDPR itself. And that would provide for the possibility of bringing an action, a representative action to protect collective interests, even independently of the mandate of the consumer. So once again, in fact, we see this increased interaction between the law and also between the regulators in the fields of data protection law and consumer protection law. Next slide, please.
2 minutes left.
Basically, I'm done. This last.
Thank you very much.
No, that's okay. This last slide about cooperation, just because, of course, we live in a world where infringements of legislation are not likely to be limited to a domestic space, but are more likely to be cross-border or indeed affect the entire European Economic Area. So just a reference to the regulation on cooperation between national authorities responsible for enforcement of consumer protection laws, which lay down a cooperation framework to effectively deal with the breach of consumer protection legislation. And these national authorities, therefore, are through this cooperation network, are better able to deal with dark patterns which have a cross-border dimension, including EU-wide enforcement against a trader responsible for the deployment of a dark pattern. And we thank you for your attention. And
thank you very much, Mireille. Thanks a lot. I'm sorry for pushing, just I can see we have
Okay, I understand.
We have a lot of participants, so I'm sure that some of them will have some of their questions and comments in relation to this extra popular and extra important topic now. So again, many thanks. Now, first, Dr. Agustn Reyna from EuC, with kind of 15 minutes we have for your comments. Again, many thanks for being with us here today. Please, the floor is yours.
Thank you very much, Mateja, for the very kind invitation, and also to the your co-editors for organizing also this event, which is very timely and highly interesting. I don't know if we could take the view of this the slide. If somebody could stop sharing the screen, so that is I can also see the.
I think Mark is the boss with the slide.
Excellent. Thank you, Mark. And thank you very much, Mark, for Mireille for this excellent and very stimulating paper, which I very much enjoy reading. And something that I particularly like is I really enjoy when non-consumer law scholars or contract law scholars write about consumer protection. I think that makes the discussion extremely enriching and very insightful. So really thank you for digging into this area with a topic which is of great interest across disciplines. Certainly, data protection has a lot to say. Of data protection scholars, they have a lot to say about the use of dark patterns. Recently, the CNIL in France have actually fined Google on the basis of engaging in dark patterns in the way they display the cookies policies. And like this, we have seen a lot of cases and developments across jurisdictions in Europe. What I found very interesting in your paper relates on the fact that it's important to have a common understanding of the problem. What are we talking about? And I think in this regard, the idea of developing a taxonomy is very helpful as a way to be able to map what are the practices out there. At the same time, there is a risk with the taxonomy that we might not capture other practices that effectively could be considered as dark patterns, but as a way to map what is happening out there, I found it extremely useful. Also, in order to assess how the existing rules would apply to those situations and whether there could be gaps and areas that need further consideration. When it comes to the discussion of dark patterns, which essentially goes about manipulation of choice architecture, I like to approach it from the point of view that this is not a new phenomenon. Persuasion and manipulations has always existed, but at the same time it's different. And it's different because digitalization have introduced a new dimension. So far, when we look at consumer protection, we try to tackle on one side the lack of bargaining powers between the parties, so the consumer and the professionals, and the information asymmetries. So, for example, in the past we have targeted the fact that we know very little about companies, and the information that they hold. But now there's a new dimension. There's not only that we don't know enough about the companies, but we don't know how much they know about us. And I think this is a particular feature of these practices, because thanks to what they know about us and thanks to the predictions that they can make about how we can react to certain information or features or design features, they can also anticipate and therefore influence our own behavior. And this is something that was not considered, for example, when all this legislation, these consumer protection rules were adopted. So this is certainly a new element, which put us on what we call constant state of vulnerability. It's a situational vulnerability. It's not the vulnerability that we have considered because of the particular physical, mental, or financial circumstances of the individual consumer, but because on a situation that we can all be vulnerable at some point in our lives because of the circumstances in which we are. For example, I can be extremely vulnerable when I sit in front of the bank to negotiate a mortgage, despite the fact that I might know a lot about consumer protection, but still I don't know how the specific markets work. So therefore I can be put in a situation of vulnerability. And like this, it can happen across market circumstances. Another element that I really much enjoy in your paper is the fact that you acknowledge through your analysis that consumer protection is, and I quoted what it say, uniquely qualified to address with these issues. And it's very interesting because I first of all, I very much agree because of the way that consumer protection is structured and the values in which consumer protection is rooted, fairness being, of course, one of them. And also that shows the unexploited potential that consumer protection has in this area. And one of the main problems that we have is related to the lack of enforcement and lack of experimentation. So we have all these new practices, but we have little experience about how the existing framework apply in concrete scenarios and concrete cases to all these practices. How, for example, a given dark pattern could be framed under the EuCML as a misleading omission or misleading action, or even as an aggressive practice. We have some examples and cases at national level, and you have certainly mentioned the Italian cases that I think are quite interesting. But we need more experimentation and see more cases in order to obtain more clarity about the scope of application of this of the existing rules. From the European Consumer Organization, where we are starting thinking also about these questions, and we have a project, Consumer Protection 2.0, we call it, in which we are specifically looking at how the EuCML, for example, should be adapted in order to address all these new challenges, including their patterns. And here there are two specific recommendations that will be interesting to discuss and also get your views on. One relates on something that you have raised in your paper, which is the average consumer benchmark. And here is the fact that the legislator and the courts have taken a very particular view of the image of consumers that not necessarily correspond to the reality. Consumers simply do not read terms and conditions because they don't have time to read terms and conditions. And this is something that we need to acknowledge, both at the level of legislation and as well as at the level of enforcement. So there is a need, for example, to lower this benchmark in the legislation and the case law. And one way will be to introduce, for example, a new concept like digital asymmetry, which will allow the enforcer in the concrete case to assess what are the circumstances surrounding and that individual consumer and see how the corresponding practice affects its agency and decision making. And the second point, which I think is particularly important in the context of public enforcement, relates to the burden of proof and the alleviation of the burden of proof. Because of course, if we will ask agencies and consumer authorities to carry out A/B testing every time they face what it seems to be a misleading user interface, that will be extremely burdensome. So here might be helpful to have a rule which basically requires and allows the enforcement authorities to request information from the concerned companies to show basically why a certain practice is not misleading, or what is the studies that they have carried out, the testing that they have carried out to effectively assess the fairness of the practice. And then the last point that I would like to address, which is also mentioned in your paper, when we look through all the different instruments that apply to this new and growing phenomenon, relates to the gaps that currently exist and whether there is needs actually to adapt it or improve it. I think a very important step has been the publication of the Commission's EuCPD guidance document that now is a notice. So that's also quite interesting itself, because finally we have an institutional framework for this guidance. Before it was just a guidance document produced by DG JUST. Now this is a Commission notice, so this is not a minor element. We have also seen some guidance at national level as well. So the Dutch ACM, the Consumer and Competition Authority, they have produced very interesting guidelines on user interface design, which I think help to better understand how the EuCPD would apply, or most precisely what will be the obligations emerging from the EuCPD in relation to the design of a user interface. But we cannot forget that guidance documents and notices are not binding. And there is, of course, a risk that the courts might take a different view. So, for example, I think the Commission has been right in its assessment regarding how the EuCPD would apply to their patents, the scope of the professional diligence. But this is, of course, the particular view of the Commission. The courts might take a different perspective. And we have seen that, for example, regarding the guidance document on the Consumer Rights Directive, where the Commission considered that a mattress falls outside the scope of the right of withdrawal, even if that was not explicitly included as an example in the Consumer Rights Directive, but the court took a different view in the Slewo case. So I think one also needs to be conscious about the limitations of guidance instruments. And however, in the consumer agenda, the European Commission already considered in this action point 7 the eventual need for future legislation. And here is quite interesting to consider whether, if we can identify that there are effectively gaps in the EuCPD, then additional legislation might be needed. And there is an ongoing study by the European Commission, DG JUST, on unfair practices in online environments. I think I have the opportunity to participate in different stages of the study, and I found extremely interesting how they have identified different practices, and now we are discussing whether there are gaps that need to be addressed. I don't know if there will be somebody from DG JUST in this call, and surely they could complement what I'm saying in relation to the study. But at the same time, dark patterns is a topic that is popping up also in other discussions. For example, in the Digital Markets Act, there is a specific mention to addressing dark patterns in what we call the anti-circumvention clause. I don't know if many of you might be familiar with the DMA, the Digital Markets Act, which include a specific list of obligations for gatekeeping platforms. So and some of these obligations are really consumer facing. So, for example, combination of data. You cannot, as a gatekeeper, combine data from different services in order to provide a personalized service to consumers. And before you first obtain the consent according to GDPR, but also provide the consumer the option to opt for a non-personalized service. So this is a very specific obligation in the DMA. But of course, through the use of dark patterns, it will be extremely easy for a gatekeeper to push consumers towards the personalized service, and therefore agree on the combination of the data. So the idea of the legislator is to include in the anti-circumvention clause the possibility also for the enforcer, in this case the European Commission, to assess whether whether the gatekeeper have not engaged in technical or behavioral techniques, including measures including design interface, in order to bypass the compliance obligations. Of course, this is not a prohibition of dark patterns per se, also because it's including asymmetrical legislation, but it still is really interesting to see how the legislature is also thinking about user interface design as a potential means to bypass obligations, including the DMA. The DSA, the Digital Services Act, as well, is in the European Parliament, have tended to include a specific reference to dark pattern protection, but it's always in relation to intermediaries. So now leaves the question, well, then we have the horizontal rules, so the technology neutral EuCPD and CRD. And as I said before, I think there is a lot of potential to enforce it better and more. against this type of practices, but there is also scope for reform. And I would like to pick up one of the examples that you mentioned, Mark, the Ryanair example, which is I remember at the time Ryanair was simply, you know, pre-ticking all the boxes, and then by default you already accepted to have an insurance, which was not so interesting and quite pricey, if I remember well. But of course, many people just simply didn't untick it and just went for it, and then they realized that they paid for it after they have concluded the contract, or sometimes they even didn't realize because they thought it was part of the contract. And at the time, actually, the legislator considered that practice not to be acceptable and decided to ban it in the Consumer Rights Directive 2011. So basically, that practice has to stop, and you cannot pre-tick any agreement that would require the consumer to make a payment. And what is interesting is that now what we are seeing is, for example, in the case of Amazon Prime, that was raised by one of the members, that it's so easy to get into a contract, but it's so difficult to terminate the contract because through the use of user interface and tricks, they make it very difficult. You need to go through many steps in order to cancel a subscription. So Germany actually had been discussing the similar situation that we have in the CRD in relation to entering into a contract, but now getting out of the contract. So basically, they have proposed in a Fair Contracting Act the fact that providers and traders should display also a termination button to make it easy to terminate the contract and get out of the contractual relationship, as easy it is to get into the contract. So this is also a response to these new trends and new practices. It will be interesting also to see whether that is something that could be foreseen in an eventual and potential review of the Consumer Rights Directive. And then the very last point, and I don't want to take too much time, relates to the enforcement that you mentioned, Mireille. I think again, I said before, we're generally speaking under enforcing consumer law to start with, but I think in this area we're particularly under enforcing it, and it's really interesting that now we have, and it's still a mechanism in testing and experimentation, which is the CPC net and the external alert, and the fact that now we have a mechanism which I think is quite promising, allowing the national authorities to discuss all this issue and coordinate the enforcement against companies that are applying the same practices across member states, so in the form of union-wide infringement. So I think that we could be seeing, and we should be seeing more action from the CPC in this regard, because that really helps the national authorities to join forces against this type of practices and this type of companies, which are quite big as we know. So just to finalize, I also very much like the title of your paper, "The Light to be Found in Europe's Consumer Protection Regime." And I think that here the candle is there. We just need to light it up. And certainly there is much more that can be done in the frame of consumer protection and consumer law against this type of practices. So thank you very much again for the invitation, Mateja and the colleagues.
Thank you very much, Agustn, for this kind of wonderful comments on the paper. And now I'll ask it. I don't want to abuse my position as a shareholder. I would talk a lot about, because I find this so inspiring. But Mateusz should provide his comments up to 50 minutes, please. The floor is yours, and then we'll have some time for the discussion. I already see some questions in the chat. But first, Mateusz, please.
Yes, so thank you, Mateja. Thank you also, Mark and Mireille and Agustn for your presentations before, that were also very instructive for me. Also partly consumed some questions I would like to tackle upon in my presentation, in my comments. So I have three principal issues I wanted to address in response to your paper, but also partly in an attempt to build a kind of a follow-up to what you've been talking about in your highly interesting piece that we are very happy to publish in the last issue of EuCML. Let me share my screen for a moment, just in order to make it. Sorry, I have it. Okay, just to make it perhaps more clear what I would like to talk about. So first of all, I would like to ask you about the general justification or the general perception of whom we should prepare, we should protect, and for what reason these persons in particular should be protected when it comes to dark patterns. So in other terms, I would like to ask you, to what extent you think, while thinking of dark patterns, we should confine to the, I would say, more like conventional patterns of EU consumer law, which are more or less centered around the question of the economic interests, the question of making rational market decisions, but market decisions which somehow may have the impact on the economic well-being of the consumer, on the economic welfare, and which can be more or less expressed in pecuniary terms. Or to what extent we can, or we should, think about dark patterns in a different way. So as the possible threat to the other kinds of consumer interests, for example, the question of privacy, the question of autonomy, but not necessarily autonomy towards one's economic interests, but rather autonomy towards one's data, towards one's self-expressed in terms of the information about ourselves that we should have control upon. And also towards autonomy vis-a-vis the possible manipulation and possible luring towards some patterns, some schemes that would exploit our cognitive constraints, the biases we have in our decision-making processes, and so far. So in other terms, do you think we should consider dark patterns issue mostly as the problem of the economic interest of consumers that are at stake? In particular, when we are thinking about data as the commodified object on the market, as a new type of asset on the consumer market, or should we at least partly depart from this understanding of dark patterns and move rather towards the question of the other non-economic types of consumer interest, consumer harm that can be at stake? Secondly, and this is something that Agustn has already mentioned in his presentation regarding this highly interesting consumer 2.0 study of BEuC. So the question of the average consumer benchmark, because in your paper, you refer to several acts of the existing consumer acquis, such as the EuCPD, Unfair Commercial Terms Directive, Consumer Rights Directive, each of which to some extent employs this notion of the average consumer as a benchmark for example, consumer information, for evaluation whether the particular practice could or couldn't be misleading or deceptive towards the consumer, and so far. So do you think that regarding the consumer law as it is now, we should still follow this again quite conventional classical notion of the average consumer, or should we rather seek the possibilities to make this benchmark more situation specific, more also digital market specific? And if so, do you think that we can use the concept of the vulnerable consumer that we have right now in the Unfair Commercial Practices Directive and seek some possibilities to use this gateway that the EuCPD opened in this regard to make the response to dark patterns more specific, more targeted in a way? And my third and the last question concerns, I would say, a slightly more down-to-earth doctrinal question that also arises upon your paper, and I would like to slightly challenge you upon it. So when we talk about dark patterns, from the perspective of the existing European consumer law, what are we in fact talking about? So are we talking about contract clauses? And because in your paper, one of the points is about the possibility of applying the Unfair Commercial Terms Directive to dark patterns. So to what extent we can think about them as some kind of like contractual content that can be evaluated from the vantage point of unfairness of the 9313 directive and so far. And if not entirely, what else dark patterns are? So are they a market practice? But if so, is it how to differentiate between dark patterns as a practice and as the contractual content? And further, if we think about them as a market practice, doesn't it, like in a natural way, limit our response to this issue, to this consumer threat, by somehow channeling our thinking towards the EuCPD and all the constraints regarding, for example, the average consumer notion that me and earlier Agustn were talking about. So these are my questions. I don't want to spend too much time on developing my other thoughts. I have this about this article also because I think that we'll have many comments in the discussion. So please let me put a full stop here. And again, thank you for the very exciting paper and the very interesting discussion so far. Thank you.
Thank you very much. Thank you very much, Mateusz. Now we have some time for kind of discussion with our audience. We have 65 participants, which is great. And just before, I would like just to let you know that anything you want to read about in our law journal, it has 6 issues per year, and a good article, then there are comments and analysis, and as well country reports on some actual consumer law topics. So I definitely and strongly advise you to kind of check what is going on, and because we are really will keep you updated with the recent consumer law developments in Europe. So I'm now going to collect questions. Would you please kind of raise your hands, and then I prefer if you could ask questions in person than if you write in chat. I would like to hear first 3 questions. If you could present yourself, tell us who you are, where you kind of, which institution you come from, and ask the question, please. I just don't see has someone raised their hand.
I think, Mateja, we already had some questions in the chat, so maybe we can start with them.
Okay, we can. Fabiana Di Porto has asked, could you please elaborate a bit on what the DSA could do of different from other pieces of legislation to tackle data protection? This question was directed to whom? Fabiana, could you please say? To the authors or to Agustn?
Okay, that would be an Agustn question.
Yeah, this was directed to Agustn, but I mean, even the authors, if they want to, unfortunately, I didn't have time to read the articles, but I mean, whoever wants to reply, I would be happy to listen to the replies. Thank you very much.
Thank you, Fabiana. Agustn, would you like to reply?
Yeah, of course. Happy to take that one. So the DSA addressed the issue of dark patterns, but only in the context of intermediation services. So here we're talking about something really, really limited. And I have here the text in front of me. Basically, what the council has suggested is that the very large platforms, so again, we are talking about asymmetric legislation regarding the size of the platform, the different criteria to define that, but they have for very large platform not to seek to subvert, impair the autonomy, decision-making, or choice of the recipient of the service through the design, structure, function, or manner of operating their online interface. This is what that the council has done. The parliament has extended basically to all online interfaces of providers of intermediation services. So again, this is very limited. This is not a ban on dark patterns. It follows a little bit the same idea or approach of the DMA, so making sure that where the DMA or the DSA, in this case DSA, provide for the obligation to give certain choices to the consumer in relation to the intermediation services, that the relevant party cannot, through the design, alter that choice, basically push the consumer towards one or another option. But this is far from being a ban on dark patterns, and in that regard, it could add something in relation to these intermediation services, or clarify in relation to intermediation services. But if this issue, we will solve it, or will have been solved in the horizontal consumer protection, then such a provision will not be necessary in the first place. But I think what it's trying the legislature to do is basically to complement and anticipate that in relation to these intermediation services, consumer agencies should not be undermined through the design interface, which is a positive obligation that we don't have in the horizontal consumer protection framework. I hope that that helps.
Thank you very much.
Catalina, is this a comment you would like to say it, or it's more a question, or would you like to say something, because I posted twice already in the chat?
Yeah, so hi everyone, good afternoon. Thank you very much, Mateusz and Mateja, for hosting this wonderful webinar. For those of you who don't know me, which I think that's not going to be that many people in this room, I'm Catalina Goanta, an assistant professor at Maastricht University, and someone who's very honored to be one of the editors of EuCML. First of all, Mark and Mireille, really wonderful paper. It was really a pleasure to read it. And I think that you've done a phenomenal job mapping and then kind of canvassing the insane, if I may call it like this, amount of literature that has been going on dark patterns, has been going around on dark patterns in the past couple of years. So I think that this is really phenomenal. And I think maybe just to kind of create a bridge between what Mateusz was mentioning earlier. So, I mean, this is, I think, something that perhaps we can hear from all of you if we have time. But just to bridge basically what Mark, you were mentioning, the perspective of cognitive psychology, but also what Mateusz was mentioning, the average consumer, right? So, and also this very normative test in the EuCPD. From what I can gather in this topic, we're kind of at a crossroads where we're talking about a lot of empirical research, a lot of behavioral research that really aims to understand and to try to measure consumer harms. We have a colleague who has co-written a fantastic book on it, Christine Riefa, the consumer harm theories. But so we still are kind of having some problems trying to measure the harms in digital markets. So the way I see it, we're kind of standing at this crossroads where on the one hand, we can just simply embrace the normative tests that we have seen in the EuCPD that, you know, if you read the EuCPD carefully, the roots are in defects of consent from national jurisdictions, the idea of what would Lord Denning say if you use a reasonable person standard and you try to ask yourself in this particular jurisdiction, what would be reasonable to say that, or in which situation would the consumer be deceived or an individual be deceived? So we have these normative, very doctrinal tests that legal scholarship has been writing about, I would say, for centuries. And then on the other spectrum, on the other part of the spectrum, we have these more kind of empirical measurements that come with a lot of limitations because of issues like consumer preferences, demographics, and a lot of such minute elements that will influence the way in which we can ascertain, even when we try to measure the impact, for instance, of a dark pattern on the behavior of individuals. Will the Ryanair website, you know, will people react? I mean, and I think Mark, you took this very typical example with Ryanair, right? And that's, I think it's a very dire example of a dark pattern. But, you know, if we're speaking about timers, and if we're speaking about this gray area between will timers influence behavior in any case, or will fake timers be unfair practices? What if Swedish consumers react in a different way, or maybe urban Swedish consumers of a specific age will react in a different way? And then if we embrace this type of test, then, you know, good luck to us trying to figure how to create useful measurements and how to actually enforce that, and how to use these these kind of tests in a judicial framework. So my question to you all is, what's the path? What do we choose? Do we choose each, or do we choose one of these two routes, or do we choose something in between? I'm very curious about your insights into this dimension of dark patterns. Thank you.
Yes, please, the authors, if you would like to reply. Galina's question, thank you.
Well, there's a lot to unpack in that question and those comments. I think the purpose of this paper, when we set out to write it, was to look objectively at the consumer protection paper or the regime from people that weren't familiar with it, to see where it could plug the gaps that the data protection regime didn't. What I hinted at, where my work is going, is a proper mapping exercise onto various parts of the EuCPD. One of the risks, I think, that is correct in identifying and developing a taxonomy of that nature is that you skip out on some. And there's one glaring oversight that's already taking place. This is that we're talking about dark patterns in the context of user interfaces, but we're not talking about dark patterns that take place in the system architecture. And one of the things that I am the examples that I can offer here, which I can't give you a nice visualization, but if you would spare me a couple of minutes to talk you through this, I know of an app that is offered by the gig economy taxi company, a gig economy taxi company that orchestrated a dark pattern which looked at the battery power of the mobile phone of their users. Now, it doesn't take a genius to say that if you marry that data with your location data, the time of day or night, and even information about the sex of the user, that you can make inferences about the vulnerability and the state of vulnerability that that person is in when you deploy the dark pattern, that raises the rate at particular levels of battery power. So they know that that battery power is going to be, the phone is going to be out of charge in a few minutes, and that it might take them a bit of time to get another provider. And by that very nature, it's irrelevant for me whether that person is a vulnerable consumer, because they're vulnerable in that moment. And I see that as something that we really shouldn't having be a dialogue about. If you're accessing battery power and changing rates on say, for example, if anybody on a train traveling home and needing a taxi late at night to get home, then you're doing something that should be regulated, and the law should protect that person from that type of practice. What I would say beyond that is that we have to maybe answer some of the other questions that were put out while I'm trying to answer Catalina's. I never wanted to sort of have this kind of like, okay, well, this is the one rule for all dark patterns. I think there are so many dark patterns that we have to look at both the intent and the way that the consumers are exercising or behaving in relation to the dark pattern, and then have a set of rules relative to the dark pattern and what motivation is underlying it. So maybe the next step is taking a look at more a pluralistic approach between data protection and consumer protection, for looking at what one regime could complement another. Another step might be doing a really formal exercise of mapping out onto various provisions of the unfair commercial practices, which I've attempted to do in a subsequent paper. I also think, and again, this is my naivety as a consumer protection academic maybe comment, that I think it's time for consumer protection to develop its own set of principles that can be applied to data and data-driven technologies, in the same way that is set out in other aspects of information technology law. I think balance and equilibrium might be a principle that could be applied, that you can't weight yes any different than no, or you can't weight entering into an agreement any different than leaving an agreement. So you can measure the steps out. It's an empirical exercise. Did it take 2 steps to join? Well, it should take 2 steps to leave. Design should be assessed on not how it affects consumers, but how influential it is at making the consumer do a certain thing. So if 90% of the page that the user sees is dedicated toward a proactive decision that the consumer that would benefit the platform versus 10% of neutral or negative, then there's an imbalance in the way that there's a design. That might be one way that you measure fairness as a principle that can be applied to universal design practices. And one of the things I do think is important is that recognize the work that started in the design community. They have been very influential at telling the world about dark patterns. Dark patterns is their term. If you were a behavioral psychologist like Cass Sunstein, you would talk about behavioral manipulation or choice architecture. That we recognize there's a lot of good designers out there that are setting the standard, and that maybe the standard of professional diligence is directly related to the ethical obligations that designers are placing or find themselves under. That might be one way to advocate for further steps. So I don't know if that answers Catalina's wonderful question completely. I do think that it's important to exercise a kind of limitation on the concept of dark patterns at this point, because in many ways, I think it's kind of getting out of hand. There's lists and lists and lists of papers now, and we need to sort of say, okay, well, let's look, what is the intent of this design technique, and what's the outcome of this design technique, and start looking at more practical ways of putting controls on these practices. And I have long believed that the role of data as performance for a contract or counter performance in a contract and recognition by this is an important part of bringing the consumer protection into the dark pattern regulation sphere.
Mateja, can I say something?
Yeah, Larry, just is it direct comment to this, because Sylvia raised her hand before, but if you want to kind of comment something.
Yeah, I don't know if there's a queue. There's an official queuing here. Yeah, I interrupted that.
Yeah, Sylvia has raised her hand like a long time ago, so maybe if you let her.
Sure.
I think directly connect you with the
I'd
question.
be happy to wait.
Thank you, Larry. Sylvia, please.
Thanks. Actually, I thank you to everyone for organizing this, and then I obviously love the paper, and I was very happy to read that. My question was more a way to flip a little bit the perspective about the issue, because so dark patterns are only some of the strategies and techniques that are used for manipulating users online. And the application vis-a-vis consumers are only some of the applications of dark patterns. So the famous gig economy ride-sharing app mentioned by Mark also applies the exact same dark patterns vis-a-vis the drivers to push them to drive more. And so what my question is, and I don't think that really there is a right or wrong answer here, but would be to know from everyone that has spoken today, what do you think about the risk of fragmenting then the protection? Because the phenomenon from the technological and design perspective is bigger than dark patterns. And then consumer protection can cover a slice, data protection can cover another small slice, and I totally agree about the triangulation approach. But the phenomenon is bigger than that, and fragmenting the protection on some of those applications, like, you know, not providing appropriate protection to the workers of, or that are also involved in that kind of a gig economy, still lowers the protection for all the others. It's still something missing to the overall regulation of the bigger phenomenon. So I would love to hear the ideas of the speakers about that today. And thank you.
Yeah, so Sylvia, thanks for
yeah.
attending, and it's a great question. I think the European the Commission has made great inroads on this with the new Digital Workers Directive that they have proposed. Unfortunately, it's long. A couple of years back, I was at a conference where you were in attendance, and I asked a question during one of the panel discussions about this concept of user protection, where we move away from a data subject or consumer or worker and just say, if you're using the technology, let's build an acquis that solves the problem or protects whoever's using it. And that way we can stop this fragmented approach. Obviously, that didn't go very far outside of the room, because we've still developed that fragmented approach. But I think that the new Digital Workers Directive, I'm not sure if that's the name off the top of my head, is a good first step in giving that level of protection. And as long as we have that kind of that fragment in the labels, then I don't see us doing anything better.
Fantastic, thank you. Other speakers, do you want to add something? I think, Sylvia, you addressed the question to everyone, haven't you? Agustn, Mateusz, do you want to say something?
Yes, I'd like to say that
Okay.
I enjoyed this the presentation very much. Mateja and I have been asked to speak on consumer law for our friend Garen Howes at Galway, and the problem is he's a consumer law professor and I am not. So I'm watching this to try to educate myself to the bare minimums in order to give a presentation. That said, I wanted to know if anybody had come across a paper by Samuel Becker and Yuri Benenlal called Dark Contracts. If not, that might be a sort of, you know, not a highly digital directed kind of paper, but whether a contract is in paper or in a digital form really doesn't matter. You know, these type of provisions have been around pre-internet, but of course the internet allows for a lot more manipulation as in the old days. But these sort of provisions are found in contracts, and so that's the angle they take. Dark contracts might be worth a look, only because the authors are really top form in their research over the years.
Check that out. Thank you.
I just put this paper on the chat, the SSRN link.
Okay, there, okay.
Ask a question, if I may.
Yeah, you want to say something, Marco?
I just wanted to ask a question. Is fairness by design a feasible regulatory option that could be developed by consumer protection?
Yeah, and it's all this kind of, it's all very interesting in the context. You know, I've been either commentator or external examiner for 2 PhDs exactly dealing with this kind of topic. So this is very actual. And I think that, you know, especially after this PhD, one of them deals exactly with the question of fairness in this line, and as kind of, is it kind of bridge linking point between data protection rules and consumer protection rules? So it's quite interesting to see how are going to be developments in the future.
Can I maybe jump on this question?
Of course.
That's okay. I think it should be possible, you know, to develop a principle. I will even argue that principle of fairness already embedded in somehow the duties that we have. For example, the professional diligence of the directive, you know, it's kind of implied. Whether we should make it explicit, I think so. We have already sort of fairness as a guiding principle in the unfair contract term legislation. We have already well-known and established principles like fairness, good faith, fair dealing. So at the end of the day, this is just normativizing all these principles in the context of the EuCPD. And what will be interesting to reflect is what are the practical implications of having such a principle explicit. That for me will be that in the context of a design interface, that you need to take into account in the very beginning, in the design of your products, on the design of the interface, about what could be the impact on consumers. So I think this is a very important discussion, which, by the way, it was specifically mentioned, I think, in the context of the UK reform, or there was a consultation in the UK, maybe Mateja, you know better that, about the inclusion of all the recognition of such a principle in the legislation. And I think that's one of the pieces that perhaps is missing in the EuCPD context. And related a little bit to this, I would like to go back to something that Katarina, you were mentioning about this two extreme, the doctrinal test versus the empirical test. And I don't think that one extreme or the other should be preferred. I don't have a problem whatsoever to have a normative consumer image embedded in the law, but it has to be a more realistic one. Currently, we think of consumers in the law and in the doctrine as we want them to be, but not as how they are. So I think here we need to lower the benchmark, but at the same time give the possibility for the enforcement in particular to factor in their assessment what is the concrete impact on a certain group of consumers of a given practice. So still a case-by-case assessment will be very important, and this and look vis-a-vis the professional diligence duty. So I think these are the different kind of benchmarks that are taken into account when assessing a practice, particularly in the context of Article 5 as the residual unfairness control. So yeah, that would be from my side. Thank you.
Yeah, I think that's also a very good point. Now we can actually realize how far-reaching and how future-oriented was this kind of Article 5 and the General Fairness Clause. We can see to how many situations and can apply, in the meantime from 2005, in the last 70 years. It's incredible how many new consumer law challenges have occurred. Mateusz, do you have, because we're running out of time, is it an old hand or?
No, it's not. So I'm not insisting on sharing my thoughts at this point.
I mean, if you want if you want to say like last words, something.
Well, so maybe two very brief points. So first of all, I think what was very striking for me in the discussion is something that I think was somehow looming behind all discussion about dark patterns for a long time, but I'm very happy it was brought to the spotlight today. So the question of how much and if in any way dark patterns differ from what we used to have in contract law or in the online contract law practice so far. So Larry mentioned this old paper on dark contracts. Catalina, I think in one of her comments also referred to browse wrap or click wrap agreements. So these are all the concepts we've been familiar with for a long time. The question is, to what extent what we are experiencing now is different? So is it just the difference of scale, or are we having a difference in the substance of those practices? So that was the first thought I had while listening to the discussion. The second one is about EuCPD, and here I would like to partly come back to what I was saying in my comments. So whether EuCPD is really fit for grasping these new kinds of consumer interests that are under threat through dark patterns. So isn't EuCPD too much focused on consumer economic interests and the decisions on the economic level to tackle upon all of these like non-pecuniary kinds of interests or harms that consumers may experience, for example, when the data is that they share online is harvested or mistreated, mishandled. Yeah, thank you. So these are my summarizing comments. Thanks.
Fantastic. Thank you very much, Mateusz. What to tell you, I mean, for me, it was a great day and very, because actually I was teaching just before this this webinar, I was teaching for 3.5 hours exactly on commercialization of consumer data and exactly how consumer protection can be used to enhance data protection. So for me, this was kind of, I myself really enjoyed a lot this conversation. And again, in my personal name, in the name of all editors, I would like especially first to thank to the speakers today. My thanks for your time and for being with us and for your excellent presentation and excellent comments. Okay, Mateusz, this is also your and part of us, but still, thank you again, wonderful, and thank you. Like you took a lead on this, so wonderful. And of course, many thanks to all the participants, to all the audience who have come today, and especially those who have asked questions and comments. And again, this is what you should read before going to bed now or in the evenings or whatever. And of course, like in case you would like to submit something for publication, we have potentially two kind of areas, articles and comments and analysis. So we are kind of always very much looking forward to receiving good contributions to be published. So always feel free and to send us your contributions, and in advance, thank you for that. Wonderful. See you soon. Everyone stay healthy and all the best. Take care. Bye-bye.
Thank you, everybody.
Thank you.
Bye-bye.
Thank you.
Bye.
Thank you.